I am Deborah Martinez, 29 years old, and for the past 6 months, I've been locked in the most devastating legal battle of my life. The man sitting across from me in that mahogany-paneled courtroom wasn't just any opposing party, he was my father. And the woman in black robes preparing to decide my financial future, she was Professor Catherine Hayes, the same woman who had taught me contract law at Columbia and told me I had the sharpest legal mind she'd seen in 20 years. I'd love to know which corner of the globe you're watching from. And if this story speaks to you, make sure to subscribe. Tomorrow's video is one you absolutely can't miss. My father wanted to strip me of the $12 million trust fund my grandfather had left me, claiming I was financially irresponsible and morally unfit to handle such wealth. What he didn't know was that I had been quietly using that money to build something he could never have imagined, something that would change everything once the truth came out. But to understand how we ended up in that courtroom, I need to take you back to where it all began. Growing up in the affluent suburb of Westchester County, New York, our family lived in a sprawling colonial house that had been featured in Architectural Digest twice. My father, Richard Martinez, was a founding partner at Martinez, Thompson and Associates, one of Manhattan's most prestigious corporate law firms. My mother, Eleanor, served on the boards of 3 different charities and hosted fundraising galas that regularly raised 7 figures for various causes. From the outside, we appeared to be the perfect American success story. Inside our home, however, everything revolved around one central principle: the Martinez family legacy must be preserved and enhanced at all costs. My older brother Marcus was the golden child, the heir apparent who would one day take over Dad's law firm and continue the family tradition of legal excellence. At 32, he had already made partner at a different firm, married his college sweetheart Sarah, and produced 2 grandchildren who were the absolute center of my parents' universe. Marcus possessed the exact qualities my father valued most: unwavering ambition, conservative values, and an instinct for making money. He drove a BMW, lived in a Connecticut mansion, and attended the right country clubs. Every conversation at family dinners seemed to revolve around his latest courtroom victory or his children's achievements in private school. I, on the other hand, represented everything my father found incomprehensible about the younger generation. While Marcus had followed the predetermined path from Ivy League undergraduate to law school to corporate practice, I had taken what my father considered dangerous detours. After graduating from Yale with a degree in international relations, I had spent 2 years with Teach for America, working in underserved schools in Detroit. My father viewed this as an expensive waste of time, a phase I needed to get through before settling into serious adult responsibilities. When I returned from Detroit and announced my intention to attend law school, he was pleased but insisted I focus on corporate law, like the rest of the family. Instead, I found myself drawn to civil rights law, immigration advocacy, and social justice causes that made my father visibly uncomfortable. During law school at Columbia, I spent my summers working for nonprofits and public interest organizations instead of the high-paying corporate internships my father arranged for me. I turned down offers from white shoe firms to work at a small practice that specialized in representing undocumented immigrants facing deportation. My choice of career path wasn't just professionally disappointing to my father, it was personally offensive. He saw it as a rejection of everything he had worked to build, a squandering of the opportunities and connections he had spent decades creating. The tension in our relationship had been building for years, but it crystallized around one central issue: my inheritance. My grandfather, Roberto Martinez, had immigrated to the United States from Mexico in 1952 with nothing but determination and a willingness to work 18-hour days. He had built a construction empire from the ground up, eventually owning commercial real estate across 3 states. Unlike my father, who had distanced himself from his immigrant roots as he climbed the social ladder, my grandfather had never forgotten where he came from.
Roberto had always been my closest ally in the family. While my father criticized my career choices and my mother worried about my unmarried status, my grandfather listened to my stories about the families I was helping and the cases I was winning. He understood that success could be measured in more than just dollars and social status. When Roberto passed away 2 years ago, his will contained a surprise that shocked everyone except me. In addition to leaving the bulk of his estate to my father, he had established a $12 million trust fund specifically for me, with very particular conditions attached. The trust would be released to me on my 30th birthday, which was still 8 months away. Until then, I could access limited funds for education, housing, and what the document called charitable endeavors aligned with the grantor's values of service to the immigrant community. My grandfather's lawyer, James Wellington, had explained to our family that Roberto had been very specific about his intentions. He wanted to ensure that at least one member of the next generation would continue his legacy of helping others achieve the American dream, even if the rest of the family had moved on to different priorities. My father's reaction to the will was immediate and furious. He felt that Roberto had undermined parental authority and family unity by creating what he called a reward for rebellion. In his view, the trust fund would only encourage his irresponsible career choices and delay my eventual return to the family fold. For months after the funeral, my father had tried various approaches to convince me to voluntarily transfer the trust to him for proper management. He offered to invest it more aggressively, to use it as seed money for a family foundation that he would control, or to simply hold it until I came to my senses about my career. Each conversation became more heated than the last. My father couldn't understand why I would want to waste money helping people who, in his words, should solve their own problems instead of relying on handouts. I couldn't understand how he had become so disconnected from the values that had made our family's success possible in the first place. The breaking point came 6 months ago, during a family dinner at my parents' house. Marcus and Sarah were there with the children, and the conversation had turned to my work as usual. I had just won a significant case preventing the deportation of a family that had been in the country for 15 years, and I was excited to share the news. My father listened to my description of the case with growing irritation. When I finished, he set down his wine glass and looked directly at me with an expression I had never seen before. "Deborah," he said in the cold, measured tone he used in depositions, "this has gone on long enough. You're nearly 30 years old and you're still playing games with your life. That money Roberto left you was supposed to help you build something real, not subsidize this fantasy of being some kind of social crusader." The room fell silent. Even the children seemed to sense the tension and stopped their chatter. "Dad," I replied carefully, "Grandpa Roberto left me that money because he believed in the work I'm doing. He understood that helping people isn't a fantasy, it's a responsibility." Marcus cleared his throat uncomfortably. "Maybe we should talk about something else." "No," my father interrupted, his voice rising. "This family has indulged in this phase long enough. Roberto may have thought he was helping you, but all he did was enable you to avoid growing up and take responsibility for your position in this family." My mother placed her hand on his arm, trying to calm him, but he shook her off. "That trust fund is going to ruin you, Deborah, and I won't stand by and watch it happen. One way or another, that money needs to be managed by someone with actual business sense." I stood up from the table, my own anger finally matching his. "That money doesn't belong to you, Dad. It belongs to me. And Grandpa Roberto made his wishes very clear. I'm going to honor his intentions whether you approve or not." My father's face darkened. "We'll see about that." I should have recognized those words as a threat, but I was too angry and hurt to think clearly. I grabbed my purse and left without saying goodbye to anyone else, driving back to my small apartment in Brooklyn with my hands shaking on the steering wheel. That was the last normal conversation I would have with my father for months. What I didn't know as I drove through the Manhattan traffic that night was that he had already begun the process that would lead us both into a courtroom, with the most important relationship of my life hanging in the balance. The first sign that my father was serious about his threat came 3 weeks after our confrontation at dinner. I was reviewing case files in my cramped office at the Legal Aid Society when my assistant, Maria, knocked on my door with an expression of concern.
Deborah, there's a process server here for you, she said quietly. He says it's urgent. My stomach dropped as I accepted the thick manila envelope. Inside were documents that would forever change my relationship with my family. Richard Martinez versus Deborah Martinez, petition for trust fund administration and conservatorship. I read through the legal papers with growing disbelief. My father wasn't just challenging the trust, he was asking the court to declare me mentally incompetent to manage my own finances. The petition claimed I suffered from poor judgment, financial irresponsibility, and an inability to make sound decisions regarding substantial assets. As evidence, he cited my choice to work for nonprofits instead of pursuing lucrative corporate positions, my modest living arrangements despite having access to trust funds, and what he called my pattern of making emotionally driven decisions that prioritize ideology over financial stability. A lot of love and effort went into bringing this story to life. If you're enjoying it, we'd be so grateful if you'd subscribe to our channel. Now, back to where we left off. The most devastating part wasn't the legal language. It was seeing my life choices described as symptoms of mental incompetence by the man who had raised me. Every career decision I was proud of, every case I had won, every sacrifice I had made to help others was being twisted into evidence that I couldn't be trusted with my own inheritance. My hands were shaking as I reached for my phone to call James Wellington, my grandfather's lawyer who had helped draft the trust. He answered on the second ring, and I could hear the frustration in his voice before I even explained why I was calling. "I've been expecting your call," he said grimly. "Your father's attorneys contacted me yesterday, demanding all documentation related to the trust creation. I told them they'd need a court order, but I suspect that's exactly what they're working toward." James had known my family for over 20 years, having handled various legal matters for my grandfather's business empire. He had watched me grow up and had been present for many family gatherings where my father's disapproval of my choices was obvious. "Deborah, I need you to understand how serious this is," he continued. "Your father has hired Blackstone, Murphy and Associates. They're one of the most aggressive litigation firms in the city, and they specialize in complex trust disputes. This isn't going to be a simple family disagreement. This is going to be a full-scale legal war." The weight of the situation began to sink in. Blackstone, Murphy and Associates had a reputation for taking no prisoners in high-stakes financial litigation. They were the firm wealthy families hired when they wanted to destroy their opponents completely. I needed my own representation, and I needed it fast. Unfortunately, my salary at the Legal Aid Society barely covered my modest rent and student loans, let alone the kind of legal fees this case would require. Most of the trust fund remained inaccessible until my 30th birthday, and even the limited funds I could access were restricted to specific purposes that probably didn't include defending against my own father's lawsuit. My first call was to David Kim, a law school classmate who now worked at a mid-sized firm that handled some trust litigation. I explained the situation over lunch, watching his expression grow more serious as I detailed my father's claims. "This is really ugly, Deborah," he said finally. "Trust fund challenges are always personal, but when it's family versus family, things can get incredibly nasty. And the conservatorship angle, that's particularly brutal. If they can convince a judge that you're incompetent, you could lose control of not just the trust, but potentially all your financial decisions." David agreed to represent me at a significantly reduced rate, but even his discounted fees would strain my limited resources. More concerning was his honest assessment of our chances. "The problem is that your father's argument isn't completely without merit from a traditional perspective," he explained. "You are choosing to live on a nonprofit salary when you could be making 10 times that amount at a corporate firm. You are prioritizing social causes over wealth accumulation. In the eyes of a conservative judge, especially one from your father's generation, that might indeed look like poor financial judgment." Over the following weeks, I threw myself into preparing our defense while still maintaining my caseload at Legal Aid.
The irony wasn't lost on me that I was fighting for my right to help others while simultaneously needing help myself. The discovery process began, and my father's attorneys requested documentation of every financial decision I had made since graduating from law school. They wanted bank statements, tax returns, records of charitable donations, and detailed explanations for what they termed my unusual lifestyle choices. Most invasive of all, they requested permission to interview my colleagues, friends, and even former clients to build their case that I lacked the judgment necessary to manage substantial wealth. I watched in horror as people I cared about were dragged into a legal battle that had nothing to do with them. My supervisor at Legal Aid, Carmen Rodriguez, was among those who received subpoenas. She had been a mentor to me since I started working there, and I dreaded the conversation where I had to explain why she was being pulled into my family's dysfunction. "Let me understand this correctly," she said after I finished explaining. "Your father is arguing that your choice to help immigrant families makes you mentally incompetent?" I nodded miserably. "According to his lawyers, my salary and living situation are evidence that I can't make rational financial decisions." Carmen was quiet for a long moment, then laughed, not with humor, but with the kind of bitter recognition that comes from understanding systemic injustice. "Deborah, do you realize what this case really represents? Your father is essentially arguing that caring about other people is a form of mental illness, that choosing service over profit is evidence of incompetence. If that's true, then half the lawyers in this office should be declared unfit to manage our own affairs." Her words helped me realize that this case was about more than just my trust fund. It was about two fundamentally different definitions of success and responsibility. My father saw wealth as something to be accumulated and preserved for its own sake. I saw it as a tool that could be used to create opportunities for others. The preliminary hearings began in October, and I got my first glimpse of just how personal this battle was going to become. My father's lead attorney, Patricia Blackstone herself, painted a picture of me as a naive idealist who had been manipulated by my grandfather's outdated immigrant mentality. "Your Honor," she argued during one motion hearing, "Miss Martinez has consistently demonstrated an inability to distinguish between charity and sound financial planning. She has chosen to live in near-poverty conditions while sitting on access to millions of dollars. This pattern of behavior suggests a fundamental disconnect from financial reality that makes her unsuitable to manage such substantial assets." Listening to my life's work being described as evidence of mental incompetence was devastating. But what hurt even more was seeing my father sitting at the plaintiff's table, nodding along with every character assassination his lawyers delivered. During a brief recess, I tried to approach him in the hallway. I thought maybe if we could talk privately, away from the lawyers and legal posturing, we might find some common ground. "Dad," I said quietly, catching his attention as he stood near the courthouse windows, "can we please talk about this, just you and me?" He turned to face me, and for a moment I saw something that might have been regret flash across his features, but it was quickly replaced by the cold, professional mask he wore in court. "There's nothing to discuss, Deborah. You've made your choices, and now you have to live with the consequences. Roberto should never have enabled this fantasy of yours, but I'm not going to stand by and watch you throw away everything our family has worked for." "What fantasy?" I asked, genuinely confused. "Helping people? Using my education and privilege to make a difference?" "Playing at being a savior while real lawyers build real careers," he replied. "Roberto filled your head with romantic notions about helping immigrants because he never got over being one himself. But this is America, Deborah. Success is measured by what you build, not what you give away." That conversation crystallized something important for me. This wasn't really about my competence to manage money. It was about a fundamental disagreement over what money was for in the first place. As we headed back into the courtroom, I realized that no amount of legal maneuvering would resolve the deeper conflict between us. My father genuinely believed that my values were wrong, that my grandfather had been wrong, and that the only way to save me was to force me into the kind of life he thought I should want. But I also knew something he didn't. The work I had been doing with the limited trust fund access wasn't just charitable giving, it was investment in something larger than he could imagine. Something that would prove once and for all that helping others wasn't incompatible with building wealth. I just had to survive the legal battle long enough to show him what I had really been building. The day everything changed was a gray Tuesday in November when David Kim called me with news that made my stomach drop to the floor. I was at my desk reviewing deportation case files when his voice came through the phone with barely contained excitement mixed with concern. "Deborah, you're not going to believe this. The judge assignment just came through for our case. Judge Catherine Hayes is going to preside over your trust fund hearing." The pen slipped from my fingers and clattered onto my desk. Professor Catherine Hayes, the woman who had taught me constitutional law and advanced contract interpretation during my second year at Columbia. The professor who had written on my final exam, "Ms. Martinez, your analytical approach to complex legal issues is exceptional. You have the mind of a future Supreme Court justice." More importantly, she was the professor who had changed the entire trajectory of my legal career. I could still remember sitting in her office during the spring semester of my second year, struggling with the decision of what kind of law I wanted to practice. I had been accepted for summer internships at 3 major corporate firms, all arranged through my father's connections, but something about that path felt hollow to me. Professor Hayes had listened patiently as I described my uncertainty, then asked a question that would stay with me forever. "Deborah, when you imagine yourself as a lawyer 10 years from now, what kind of problems are you solving?" Without hesitation, I answered, "I want to help people who can't help themselves. I want to use the law to protect people who don't have anyone else fighting for them." She had smiled at my response and spent the next hour telling me about her own journey from corporate law to civil rights advocacy before eventually joining academia. She had connected me with contacts at immigrant rights organizations and public interest law groups, opening doors I never knew existed. "You have a gift for seeing the human story behind legal concepts," she had told me. "Don't waste that gift chasing other people's definitions of success." Those words had given me the courage to turn down the corporate internships and spend my summer working for a legal aid clinic in East Harlem instead. It was the decision that had ultimately led me to the work I was doing now. Now, 5 years later, Professor Hayes would be deciding whether my father was right about my mental incompetence. David sensed my shock over the phone. "I know this is complicated, but it might actually be good news. Hayes has a reputation for being extremely thorough and fair. She won't be swayed by expensive lawyers or family politics. She'll focus on the legal merits." But I wasn't thinking about legal strategy. I was thinking about the irony of having the woman who had inspired my career path now sitting in judgment of whether that same career path proved I was incompetent. The first hearing before Judge Hayes was scheduled for the following Monday. I spent the weekend preparing with David, reviewing case law about trust fund challenges and conservatorship standards. The legal test was whether I had demonstrated such poor judgment that I posed a risk to my own financial well-being. Monday morning arrived with the kind of bone-chilling wind that cuts through even the heaviest winter coat. David and I arrived at the courthouse 30 minutes early, but my father's legal team was already there, conferring in hushed tones near the courtroom entrance. Patricia Blackstone looked every inch the predator in her perfectly tailored black suit and steel gray hair pulled back in a severe bun. She glanced at me with the kind of dismissive look reserved for particularly weak opponents, then returned to her conversation with my father. When the bailiff called our case, we filed into the courtroom that would become as familiar to me as my own apartment over the next several months. Judge Hayes entered from her chambers, and I felt a complex mix of emotions as I saw her for the first time since graduation. She looked exactly as I remembered: silver hair, intelligent dark eyes behind wire-rimmed glasses, and an aura of quiet authority that had commanded respect in every classroom she had ever entered. When her gaze swept across the courtroom and briefly met mine, I thought I saw a flicker of recognition, but her expression remained professionally neutral. "Good morning, counsel," she said, settling behind the bench. "This is a preliminary hearing in the matter of Martinez versus Martinez regarding administration of the Roberto Martinez Family Trust. Ms. Blackstone, you may proceed with your opening statement." Patricia Blackstone rose and delivered a presentation that was both masterful and devastating. She painted a picture of me as a well-meaning but fundamentally misguided young woman who had been manipulated by an elderly grandfather's outdated values. "Your Honor, the evidence will show that Ms. Deborah Martinez has consistently demonstrated a pattern of financial decision-making that can only be described as irrational. Despite graduating from one of the nation's top law schools, she has chosen to earn a salary that barely covers basic living expenses. Despite having access to trust funds that could provide substantial investment income, she has instead used these resources for charitable purposes that provide no financial return." She gestured toward a chart that her team had prepared, showing my salary compared to the median income for Columbia Law graduates. The visual was damning, a stark illustration of how far below my potential earning capacity I was performing. "Furthermore, Your Honor, Ms. Martinez has chosen to live in substandard housing conditions in one of New York's less desirable neighborhoods, despite having the means to afford accommodations befitting her education and social position. This pattern suggests either a fundamental misunderstanding of financial principles or an inability to make rational decisions about her own welfare." I watched Judge Hayes as she listened to this character assassination. Her expression gave nothing away, but I noticed she was taking detailed notes, something I remembered from her lectures when a student made a particularly interesting point. When it was David's turn to respond, he focused on the legal standard for incompetence and the precedent for respecting trust creators' intentions. "Your Honor, the petitioner must prove by clear and convincing evidence that Ms. Martinez lacks the mental capacity to manage her financial affairs. Choosing a career in public service, choosing to help others, choosing to live modestly, these are not signs of incompetence. They are signs of different values and priorities." David presented his own evidence, my academic record, my bar exam scores, letters of recommendation from colleagues and supervising attorneys. He emphasized that I had successfully managed the limited trust funds I did have access to, never missing payments or making irresponsible purchases. But I could see that Patricia Blackstone's presentation had been effective. The visual contrast between what I could be earning and what I was earning created a powerful impression of questionable judgment. Judge Hayes called for a brief recess before announcing her preliminary ruling on discovery motions. As the courtroom emptied, I remained in my seat, staring at my hands and trying to process the surreal experience of having my life choices dissected in front of the woman who had inspired many of them. To my surprise, I felt a hand on my shoulder. I looked up to see Judge Hayes standing beside me, having approached from her chamber's entrance. "Miss Martinez," she said quietly, "I need to speak with you and opposing counsel in my chambers. There's a potential conflict of interest we need to address." My heart pounded as I followed David and the opposing legal team into the judge's private office. The walls were lined with law books and framed degrees, just like her Columbia office had been, but the atmosphere was far more formal. Judge Hayes took her seat behind her desk and folded her hands carefully. "I have just realized that I taught Miss Martinez during her time at Columbia Law School. While this doesn't automatically disqualify me from hearing this case, I believe all parties should be aware of this prior relationship." Patricia Blackstone's eyes lit up with the predatory gleam of someone who had just spotted an opportunity. "Your Honor, given the nature of this case and the need for complete impartiality, we would respectfully request that you recuse yourself and allow the case to be reassigned." I felt my heart sink. Judge Hayes was known for her fairness and thorough approach to complex cases. A random reassignment could put us in front of someone less qualified or less willing to look beyond surface appearances. Judge Hayes considered the request carefully. "Miss Blackstone, while I understand your concern, I should note that my interaction with Miss Martinez was limited to normal professor-student relations. I taught over 200 students during the years she attended Columbia, and I have no personal or financial interest in the outcome of this case. She turned to David. Mr. Kim, what is your position on this issue? David looked at me briefly before responding. Your Honor, we have complete confidence in your ability to hear this case impartially. We see no basis for recusal. Judge Hayes nodded slowly. Very well. I will remain on this case, but I want to make something absolutely clear to all parties. The fact that I once taught Ms. Martinez will have no bearing whatsoever on my evaluation of the evidence presented. This case will be decided purely on legal merit and factual evidence. As we filed back into the courtroom, I caught Patricia Blackstone whispering urgently to my father. I could only imagine her frustration at not being able to remove a judge known for her careful attention to detail and resistance to legal theatrics. But as I took my seat at the defendant's table, I realized that having Judge Hayes oversee this case was both a blessing and a curse. She knew better than anyone what I was capable of intellectually. She had been there when I first discovered my passion for helping others through the law. The question was whether she would see my career choices as the fulfillment of my potential or as evidence that I had lost my way. Judge Hayes returned to the bench and announced her decision on the preliminary motions. Discovery would proceed, depositions would be scheduled, and expert witnesses would be permitted on both sides. As the hearing concluded and we gathered our papers, I realized that the real battle was just beginning. My father had hired the best lawyers money could buy to prove I was incompetent. I had limited resources and an uphill fight. But I also had something they didn't know about yet, a secret that would change everything once it came to light. I just had to survive long enough for the truth to emerge. The deposition phase of the lawsuit began in December, and it quickly became clear that Patricia Blackstone intended to dissect every aspect of my life with surgical precision. She had scheduled interviews with my colleagues, my landlord, my bank manager, and even my college roommate from Yale. The most brutal deposition was my own, conducted in the sterile conference room of Blackstone's Midtown law firm. For 6 grueling hours, she grilled me about every financial decision I had made since graduating law school, every charitable donation, every choice to turn down higher-paying opportunities. Ms. Martinez, she said, consulting her notes with theatrical precision, in the past 3 years, you have donated approximately $47,000 to various immigrant rights organizations. That represents nearly 40% of your annual salary. How do you justify giving away money you can barely afford to spare? I had prepared for this question with David, but sitting across from Blackstone's cold stare made my rehearsed answer feel inadequate. I believe that those with privilege have a responsibility to help others. My grandfather built his wealth specifically because he understood the barriers facing immigrant families. But wouldn't those families be better served if you had taken a higher-paying position and could therefore donate even more money? She pressed. Your current approach seems both financially irrational and ultimately less effective. It was a trap I couldn't escape cleanly. If I admitted that earning more would allow me to give more, I was conceding that my career choices were suboptimal. If I defended my current path, I was reinforcing their argument that I prioritized emotion over logic. I believe there's value in direct service that can't be measured purely in dollars, I finally answered, knowing it sounded weak even as I said it. Blackstone smiled the way a shark might smile before attacking. Ms. Martinez, isn't it true that your decision to work for legal aid rather than a corporate firm costs the families you claim to care about approximately $200,000 per year in potential donations? The mathematics were undeniable, and we both knew it. A corporate lawyer making $300,000 annually could theoretically donate far more than someone earning $55,000 and giving away 40% of it. But what Blackstone didn't know, what nobody except my accountant knew, was that her calculations were based on incomplete information.
The truth was that over the past 2 years, I had been quietly building something that would revolutionize how legal aid was delivered to immigrant communities. Using the limited funds I could access from my grandfather's trust, along with careful planning and a network of connections I had built through my work, I had been developing what would become the Martinez Immigration Legal Center. The project had started small, almost by accident. I had noticed that many of the families I helped faced similar legal challenges but couldn't afford proper representation. Existing legal aid organizations were overwhelmed and underfunded. Private immigration attorneys charged fees that were impossible for most working-class families to afford. What if there was a third option? What if technology could make high-quality legal representation more accessible and affordable? I had begun working with a small team of volunteer programmers, law students, and immigration specialists to create a comprehensive digital platform that could streamline the immigration legal process. The system would provide multilingual legal resources, automated document preparation, case tracking, and direct access to qualified attorneys for complex matters. More importantly, the platform would operate on a sustainable financial model. Families who could afford to pay market rates would subsidize services for those who couldn't. Corporate sponsors would fund the technology infrastructure in exchange for positive community impact recognition. The development had been conducted in absolute secrecy. I had used a portion of my trust fund access to hire the programmers and legal consultants, but I had structured everything through a separate nonprofit entity that wouldn't be immediately traceable to me. I wanted the platform to be fully operational and proven successful before revealing my involvement. Over the past 18 months, we had conducted a pilot program serving 200 families in the greater New York area. The results had exceeded every projection. Case resolution times were 60% faster than traditional legal aid. Client satisfaction rates were 95%. Most importantly, we had helped 180 families successfully navigate complex immigration processes that might otherwise have resulted in deportation or family separation. But none of this appeared in my financial records in a way that Patricia Blackstone could understand. To her, I looked like someone throwing money away on ineffective charitable giving. She had no idea that I was actually building the foundation for what could become a national model for accessible immigration legal services. The irony was painful. My father's lawyers were arguing that I couldn't be trusted with money because I was wasting it on charitable causes. In reality, I was using my grandfather's money exactly as he had intended, to create systematic change that would help thousands of immigrant families achieve the American dream he had pursued himself. The secret weighed on me during every deposition, every hearing, every strategy session with David. I wanted desperately to reveal what I had been building, to show my father and his lawyers that I understood business and investment and financial planning better than they had ever imagined. But my legal advisors had been clear. Revealing the project prematurely could jeopardize both the lawsuit and the platform itself. If my father's lawyers could convince a court that the Martinez Immigration Legal Center represented risky or speculative investment, it would only strengthen their incompetence argument. The waiting was torture, but I had to trust that the truth would emerge at the right moment. Meanwhile, the depositions continued to chip away at my public image. Patricia Blackstone had interviewed my supervisor, Carmen Rodriguez, focusing on what she characterized as my emotional decision-making and tendency to take on cases beyond the scope of normal professional responsibilities. She had deposed my landlord, Miguel Santos, about my modest living conditions and what she termed my resistance to normal lifestyle improvements, despite available resources. Miguel, to his credit, had defended me vigorously, explaining that I was a model tenant who regularly helped other residents with their legal problems free of charge. Most painfully, she had interviewed my brother Marcus, pressing him to describe instances where I had shown poor judgment or made impulsive decisions. Marcus had tried to be diplomatic, but the transcript of his deposition made for uncomfortable reading. "Deborah has always been idealistic," he had said. "Sometimes I think she gets so focused on helping others that she doesn't consider the practical implications for herself. She's incredibly smart, but she can be naive about how the world actually works." Even my own brother saw my choices as evidence of poor judgment rather than different priorities.
The most devastating interview, however, was with Dr. Amanda Foster, a psychiatrist whom Patricia Blackstone had retained as an expert witness. Dr. Foster had never met me personally, but she had reviewed all my financial records, educational history, and career choices to provide what she called a psychological profile consistent with decision-making patterns. Her conclusions were presented in clinical language that my life sounded like a case study in mental disorder. The subject demonstrates classic symptoms of what might be termed savior complex, an unconscious psychological condition characterized by compulsive helping behavior that serves the helper's emotional needs rather than rational problem solving. This pattern often manifests in highly intelligent individuals who struggle with feelings of inadequacy or family disapproval. Reading Dr. Foster's report was like looking at myself through a funhouse mirror. Everything was recognizable, but twisted into something grotesque and pathological. She had taken every positive quality I valued about myself and reframed it as evidence of psychological dysfunction. The report concluded that I was potentially capable of learning more appropriate financial behaviors through counseling and supervised money management, but currently lacks the emotional stability necessary for independent control of substantial assets. David had his own expert witness, Dr. Patricia Mendez, a forensic psychologist who specialized in competence evaluations. Her assessment, based on extensive personal interviews and standardized testing, painted a very different picture. Ms. Martinez demonstrates above-average intelligence, excellent judgment in complex problem-solving scenarios, and a clear understanding of financial principles, Dr. Mendez had written. Her career and lifestyle choices reflect consistent values and long-term strategic thinking rather than impulsive or emotionally driven decision-making. But expert witnesses were expensive, and I knew our resources were running thin. David had been warning at dramatically reduced rates, but even discounted legal fees were adding up quickly. The pressure to settle or accept some kind of compromise was mounting. That's when James Wellington, my grandfather's lawyer, called with unexpected news that would change everything. "Deborah," he said, his voice containing barely suppressed excitement, "I think I may have found something that could turn this whole case around. Can you meet me at my office tomorrow morning and bring David with you? What I'm about to show you changed everything we thought we knew about your grandfather's intentions." As I hung up the phone, I felt a surge of hope mixed with curiosity. What could James have discovered that would make such a difference? The next morning, David and I sat in James Wellington's Wood Bevel office as he spread documents across his conference table with the precision of someone unveiling a masterpiece. "Your grandfather was far more strategic than any of us realized," James began, his eyes twinkling with the satisfaction of someone who had just solved a complex puzzle. "These documents have been sealed in a separate trust account, with instructions that they only be revealed if the primary trust was ever challenged in court." What James showed us would not only vindicate my choices, it would prove that my grandfather had been planning for this exact scenario all along. The documents James Wellington spread across his conference table looked ordinary enough: standard legal papers, bank statements, and what appeared to be correspondence. But as he began explaining their significance, I realized I was looking at evidence of the most sophisticated, long-term strategy I had ever encountered. "Your grandfather started planning this the day you told him about your decision to work in immigration law," James said, pointing to a letter dated 3 years ago. "He knew your father would eventually challenge the trust, and he prepared accordingly." The first document was a letter in my grandfather's distinctive handwriting, addressed to James, but marked to be opened only in the event of legal challenge to Deborah's trust fund. As James read it aloud, I heard my grandfather's voice as clearly as if he were sitting in the room with us.
"James, if you are reading this letter, it means Richard has done exactly what I expected him to do. My son never understood that building wealth and building legacy are two different things. He sees Deborah's work as wasteful because he measures success only in dollars accumulated, never in lives changed. What Richard doesn't know is that I have been watching Deborah's career carefully, and I am convinced she understands something about wealth that he never will. Money is a tool, not a destination. She is not wasting the family fortune. She is investing it in exactly the way I always intended. The sealed accounts I established will prove that Deborah's approach to helping immigrant families is not only morally correct, but financially brilliant.
I have been quietly funding research into her methods, and the results will surprise everyone, including Deborah herself. David leaned forward, his legal mind immediately grasping the implications. James, what sealed accounts? What research? James smiled and pulled out a thick folder marked Roberto Martinez Private Investment Portfolio, Restricted Access. Inside were bank statements, investment records, and detailed financial analyses that took my breath away. Your grandfather established a separate $8 million investment fund specifically to support and study innovative approaches to legal aid, James explained. For the past 3 years, he has been quietly financing research projects that analyze the effectiveness of different models for serving immigrant communities. The research was comprehensive and devastating to my father's case. A team of economists and social policy experts had been studying legal aid delivery systems across 15 major cities, comparing traditional nonprofit models, private attorney services, and innovative hybrid approaches like the platform I had been developing. The data was overwhelming. Traditional legal aid organizations, while well-intentioned, served an average of 12 families per attorney per month and achieved successful case resolution for 68% of their clients. Private immigration attorneys served fewer families but had higher success rates, typically resolving 85% of cases successfully, but at costs that excluded most working-class families. The preliminary data from my own pilot program was extraordinary. The Martinez Immigration Legal Center had served 200 families over 18 months with a 94% success rate and costs that were 60% lower than traditional private attorneys. The platform's efficiency allowed each participating attorney to effectively serve 35 families per month without sacrificing quality. But the most shocking revelation was yet to come. James pulled out a document I had never seen before, a detailed business plan and financial projections for scaling the Martinez Immigration Legal Center nationwide. Your grandfather hired McKinsey & Company to analyze the market potential for your approach, James said quietly. Their projections indicate that a nationwide network based on your model could serve over 100,000 immigrant families annually while generating revenues of $50 million per year. I stared at the numbers, hardly believing what I was seeing. The work I had been doing as a labor of love, the platform I had built with small trust fund distributions and volunteer labor, had the potential to become a financially sustainable national enterprise. There's more, James continued, pulling out another set of documents. Your grandfather established partnership agreements with 3 major law schools and 2 technology companies. They're prepared to provide infrastructure, training programs, and ongoing support to expand your model to 20 major metropolitan areas. David was frantically taking notes, his excitement growing with each revelation. This completely changes our legal strategy. We're not just defending Deborah's competence, we're presenting evidence that she's developed a revolutionary business model that could transform an entire industry. But James wasn't finished. The final document in the folder was perhaps the most important, a letter from the Ford Foundation expressing interest in providing a $15 million grant to support national expansion of the Martinez Immigration Legal Center, contingent on proof of concept and sustainable leadership. The Ford Foundation has been tracking your work through reports your grandfather commissioned, James explained. They believe your approach represents the most promising innovation in legal aid delivery they've seen in decades. The grant would fund training programs, technology infrastructure, and operating support for the first 50 locations nationwide. I felt overwhelmed by the magnitude of what my grandfather had envisioned. While I had been focused on helping individual families, he had been thinking about systematic change that could help hundreds of thousands of people. While I had been working in secret to avoid premature scrutiny, he had been building the foundation for something much larger than anything I had imagined. Why didn't he tell me about any of this? I asked, my voice barely above a whisper. James smiled gently. Because he knew you had to prove the concept worked based on your own vision and values, not because you were trying to fulfill someone else's business plan. He wanted you to build something authentic that reflected your own understanding of the problems and solutions. Everything else was just insurance that your good work would have the support it deserved when the time was right. The implications for the lawsuit were enormous. Patricia Blackstone had built her entire case around the argument that I was financially irresponsible and naive about business realities. The documents James had revealed proved exactly the opposite. Not only had I developed an innovative and effective approach to serving immigrant families, but I had done so with such sophistication that major foundations and consulting firms had taken notice. Far from being financially incompetent, I had created something with the potential to generate tens of millions of dollars in revenue while serving a crucial social need. David was already planning our counterattack. We need to schedule an emergency hearing to present this new evidence. This completely undermines their incompetence argument and proves that Deborah's approach is not only financially sound, but potentially revolutionary. But James held up a cautioning hand. There's one more thing you need to know. Your grandfather included specific instructions about how and when this information should be revealed. He wanted to make sure that when the truth came out, it would have maximum impact. He pulled out a final letter, this one addressed directly to me. My dear Deborah, if you are reading this, it means you have been fighting for your right to use wealth as a tool for justice rather than simply accumulation. I am proud of you for refusing to compromise your values, even when it meant standing alone against your own family. The work you have been doing is exactly what I hoped for when I established your trust fund. You have proven that helping others and building sustainable wealth are not contradictory goals. They are complementary strategies for creating lasting change. Now you must decide what comes next. You have the resources, the proven model, and the support to transform how legal services are delivered to immigrant communities across the country. But success will require you to step fully into your role as a leader, not just a helper. Your father sees wealth as something to be preserved and protected. You understand that wealth is something to be invested in making the world better. Show him and everyone else what that looks like when it's done right. The choice is yours, as it always has been. But know that whatever you decide, you have my complete confidence and support. With love and respect, your grandfather Roberto. As I finished reading the letter, I realized that everything had changed. This lawsuit was no longer just about defending my right to manage my own trust fund. It had become an opportunity to prove that my grandfather's vision, and my own, represented a better way of thinking about wealth, success, and responsibility.
The question was whether Judge Hayes would see it the same way. James gathered the documents carefully. I'll call Patricia Blackstone this afternoon to schedule a settlement conference. Once she sees this evidence, I suspect her enthusiasm for proceeding to trial will diminish considerably. But as we prepared to leave James's office, I found myself hoping that Patricia Blackstone wouldn't back down. For the first time since this legal battle began, I wanted my day in court. I wanted the opportunity to show my father, my family, and anyone else who was watching that building wealth and building justice weren't opposites. They were parts of the same larger vision. My grandfather had given me the tools to prove that helping others wasn't evidence of incompetence. It was evidence of a different kind of intelligence entirely. Now I just had to find the courage to use them. The emergency hearing was scheduled for a frigid January morning, just 3 weeks before my 30th birthday. Judge Hayes had agreed to hear our motion to present new evidence, though Patricia Blackstone had fought vigorously to prevent what she termed a desperate attempt to introduce irrelevant materials after discovery had closed. The courtroom was packed with more observers than I had ever seen for a trust fund hearing. Word had leaked about the potential significance of the case, and law students from Columbia had come to watch their former professor preside over what promised to be a landmark decision about wealth, family, and social responsibility. I arrived early with David, carrying boxes of documents that would either vindicate everything I had worked for or prove insufficient to overcome months of character assassination. The weight of the moment felt enormous, not just for my own future, but for the hundreds of families who could benefit from the Martinez Immigration Legal Center if we succeeded. My father sat at the plaintiff's table with his usual composed demeanor, but I noticed tension in his shoulders that hadn't been there during earlier hearings. Patricia Blackstone conferred with her team in hushed tones, occasionally glancing toward our table with expressions that suggested they knew their case was about to face unexpected challenges.
When Judge Hayes entered the courtroom, the packed gallery rose in respectful silence. She surveyed the room with her characteristic calm authority before taking her seat behind the bench. "Good morning, counsel," she began. "This is an emergency hearing on the defendant's motion to present newly discovered evidence in the matter of Martinez versus Martinez. Mr. Kim, you may proceed." David rose with confidence I hadn't seen from him since the case began. The revelation of my grandfather's documents had transformed him from a lawyer fighting an uphill battle to an advocate presenting a compelling victory. "Your Honor, the evidence we will present today fundamentally changes the nature of this case. What began as a petition questioning Ms. Martinez's financial competence has become an opportunity to examine different philosophies about wealth, responsibility, and social impact." He began with my grandfather's sealed letter, reading key passages aloud to establish the strategic thinking behind the trust fund's creation. The courtroom listened in rapt attention as David explained how Roberto Martinez had anticipated this exact legal challenge and prepared accordingly. "Mr. Martinez wasn't simply leaving money to his granddaughter," David continued. "He was investing in a vision of how legal services could be delivered more effectively to immigrant communities. The evidence will show that his confidence was not misplaced." David then presented the McKinsey analysis, using charts and graphs to demonstrate the financial viability of the Martinez Immigration Legal Center. The numbers were compelling enough to impress any business-minded observer. Projected revenues of $50 million annually, costs 60% lower than traditional private attorneys, success rates exceeding 90%. "Your Honor, this is not the profile of someone who lacks business judgment. This is the profile of someone who has developed an innovative solution to a complex social problem while creating a sustainable financial model." Patricia Blackstone rose for cross-examination with the determined expression of someone who recognized her case was in serious jeopardy but refused to concede defeat. "Mr. Kim, isn't it convenient that these documents suddenly appear after months of discovery? How do we know this isn't an elaborate fabrication designed to salvage an unsalvageable case?" David was ready for the challenge. "Miss Blackstone, every document has been verified by the bank that maintained the sealed accounts, the law firm that drafted the agreements, and the independent researchers who conducted the studies. Mr. Wellington will testify under oath about the circumstances under which these materials were revealed." James Wellington took the stand and methodically explained the legal mechanisms Roberto Martinez had established to protect the sealed documents. His testimony was unshakable. Dates, signatures, and banking records all confirmed that the materials had been prepared years ago, not hastily assembled for this hearing. But Patricia Blackstone wasn't finished. When it was her turn to present rebuttal evidence, she called a surprise witness that my heart sank. "Your Honor, I called Dr. Michael Stevens, Professor of Business Administration at Wharton School." Dr. Stevens was a distinguished expert in entrepreneurship and business strategy whom Patricia Blackstone had clearly hired to counter our financial projections. He approached the witness stand with the confident bearing of someone accustomed to dismantling business plans in academic settings. "Dr. Stevens," Patricia Blackstone began, "have you reviewed the McKinsey analysis and financial projections for the Martinez Immigration Legal Center?" "I have," he replied crisply. "And while the numbers may appear impressive at first glance, they reflect fundamental misunderstandings about scalability, market dynamics, and sustainable business models." Dr. Stevens proceeded to dissect every aspect of our financial projections. He questioned whether the success rates from our small pilot program could be maintained at a larger scale. He challenged the assumption that corporate sponsors would continue funding community impact initiatives. He argued that regulatory changes could undermine the entire platform overnight. "In my professional opinion," he concluded, "this venture represents exactly the kind of idealistic business planning that characterizes individuals who lack practical experience in competitive markets. The projections are unrealistic, the assumptions are naive, and the overall approach demonstrates poor understanding of business fundamentals." I watched Judge Hayes taking detailed notes during this testimony, her expression revealing nothing about how Dr. Stevens' analysis was affecting her evaluation of our case. When David rose for cross-examination, he focused on Dr. Stevens' lack of direct experience with legal aid delivery systems and immigrant community needs. But the damage was significant. Our revolutionary business model had been characterized as amateur-hour wishful thinking by a respected academic authority. Patricia Blackstone's closing argument was a masterpiece of legal theater. She acknowledged the emotional appeal of my work while systematically undermining its practical significance. Your Honor, no one questions Miss Martinez's good intentions or her desire to help others. The question before this court is whether those admirable intentions qualify her to manage a $12 million trust fund responsibly. She pointed to Dr. Stevens' testimony as evidence that my business planning was fundamentally flawed. She emphasized that even well-intentioned ventures could fail catastrophically, leaving beneficiaries worse off than if the money had been conservatively managed.
The petitioner doesn't seek to prevent Ms. Martinez from pursuing her charitable interests, she concluded. We simply ask that substantial family assets be managed by someone with demonstrated expertise in financial stewardship, allowing Ms. Martinez to focus on the direct service work she clearly loves without the burden of investment decisions she may not be equipped to handle. It was a sophisticated argument that acknowledged my competence in some areas while questioning my qualifications in others. Even I had to admit it sounded reasonable when presented with such polished professionalism. When David rose for our closing argument, he faced the challenge of countering both Dr. Stevens' critique and Patricia Blackstone's reasonable-sounding compromise. His approach was to reframe the entire question. Your Honor, this case asks us to choose between two fundamentally different definitions of financial competence. Ms. Blackstone's experts measure competence by adherence to conventional investment strategies and traditional business models. Ms. Martinez's grandfather measured competence by the ability to identify unmet social needs and develop innovative solutions. David emphasized that my grandfather had been a successful businessman who understood both approaches and deliberately chose to support innovation over convention. He pointed to the Ford Foundation's interest as evidence that major institutions shared Roberto Martinez's assessment of my work's potential. The question isn't whether Ms. Martinez's approach involves risk, David concluded. All meaningful innovation involves risk. The question is whether she has demonstrated the judgment, intelligence, and strategic thinking necessary to manage that risk responsibly. The evidence shows overwhelmingly that she has. Judge Hayes called for a brief recess before announcing her decision. As the courtroom emptied, I found myself sitting alone with my father for the first time since the lawsuit began. He looked older than I remembered, the stress of the legal battle having carved new lines around his eyes. For a moment, neither of us spoke. "I never wanted it to come to this," he said finally, his voice lacking its usual commanding tone. "I just wanted to protect you from making mistakes that could hurt you." "Dad," I replied quietly, "what if they're not mistakes? What if this is just a different way of building something meaningful?" He shook his head sadly. "I don't understand your world, Deborah. I don't understand how giving money away makes you successful, or how helping people pays the bills. It scares me to think you might struggle because of choices I could have prevented." For the first time, I glimpsed the genuine concern behind his legal assault. This wasn't just about controlling me, it was about a father trying to protect his daughter from what he perceived as financial self-destruction. "Maybe success looks different than you think it does," I said gently. Before he could respond, the bailiff called us back into the courtroom. Judge Hayes entered with a thick folder of notes and the grave expression of someone about to render a decision that would change lives forever. "Counsel, I have reached my decision in this matter. The evidence presented has been extensive and complex, requiring careful consideration of legal precedent, expert testimony, and the fundamental question of what constitutes financial competence in the management of substantial assets." The courtroom was silent, except for the sound of my own heartbeat thundering in my ears. I am prepared to announce my ruling. Judge Hayes looked directly at me as she began to speak, her voice carrying the weight of careful deliberation and years of legal experience. "This case has presented the court with a unique challenge, determining not merely whether Ms. Martinez possesses the technical competence to manage financial assets, but whether her approach to wealth management aligns with both legal standards and the explicit intentions of the trust creator."
She paused, consulting her notes before continuing. After reviewing all evidence, expert testimony, and legal precedents, I find myself confronting fundamental questions about how we define responsible financial stewardship in the 21st century. My hands were clenched so tightly in my lap that my knuckles had turned white. Beside me, David sat motionless, pen poised over his legal pad. The petitioner's case rests on the assumption that conventional investment strategies and traditional career paths represent the only prudent approach to wealth management. The evidence suggests that Ms. Martinez has indeed chosen an unconventional path, working for reduced compensation, living modestly despite access to substantial resources, and investing significant funds in what some might characterize as charitable rather than profitable ventures. Judge Hayes's words seemed to be building towards a ruling in my father's favor, and I felt my heart sinking with each carefully measured sentence. However, she continued, and the single word shifted the entire atmosphere in the courtroom. The court must also consider the remarkable evidence presented regarding Ms. Martinez's actual achievements and the sophisticated planning that supported them. She lifted a document from her folder, one of the McKinsey reports that David had presented. The financial analysis conducted by McKinsey & Company represents some of the most thorough market research I have encountered in 20 years on the bench. The projected revenues, scalability models, and social impact assessments demonstrate not naivety about business principles, but rather an advanced understanding of how to create sustainable enterprises that serve both financial and social objectives. Judge Hayes turned to address my father directly. "Mr. Martinez, your concerns about your daughter's financial decisions appear to stem from fundamental disagreements about the purpose of wealth rather than evidence of her incompetence to manage it. The court cannot and will not impose one family member's values upon another, particularly when the trust creator explicitly endorsed the beneficiary's approach." She paused to let that statement settle before delivering the core of her ruling. Furthermore, the evidence regarding Ms. Martinez's pilot program reveals extraordinary results: 94% success rate in complex immigration cases, 60% cost reduction compared to traditional services, and client satisfaction ratings that exceed industry standards by significant margins. These are not the outcomes we would expect from someone lacking business judgment or practical competence. I felt David's hand briefly touch my shoulder in encouragement, but I remained focused entirely on Judge Hayes's words. The court is particularly impressed by the interest expressed by the Ford Foundation and other major institutions in supporting nationwide expansion of Ms. Martinez's model. Such organizations do not typically invest in ventures led by individuals they consider financially incompetent. Judge Hayes set down her papers and looked directly at both legal teams. "Having considered all evidence presented, I find that the petitioner has failed to meet the burden of proving by clear and convincing evidence that Ms. Martinez lacks the mental capacity to manage her financial affairs. To the contrary, the evidence suggests that she has demonstrated remarkable innovation, strategic thinking, and business acumen in developing solutions to complex social problems." The relief that flooded through me was so intense that I felt momentarily dizzy, but Judge Hayes wasn't finished. However, this case has revealed something more significant than a simple trust fund dispute. It has demonstrated the potential for transformative approaches to legal aid delivery that could benefit thousands of families across the nation.
She turned to me with an expression that reminded me powerfully of our interactions during law school. "Miss Martinez, your grandfather clearly believed that wealth should be used as a tool for creating positive change rather than simply accumulating for its own sake. The evidence suggests his confidence in your abilities was well-founded, but with that confidence comes responsibility." Judge Hayes's tone became more serious. "The court strongly encourages you to proceed with your plans for the Martinez Immigration Legal Center, but with appropriate legal and financial safeguards to protect both the trust assets and the families you serve. Innovation involves risk, but calculated risk based on solid evidence and careful planning." She announced that she would be dismissing my father's petition entirely, with full control of the trust fund reverting to me upon my 30th birthday as originally intended. Additionally, she ordered my father to pay all legal costs for both sides, acknowledging that the lawsuit had been frivolous given the evidence of my competence.
As Judge Hayes concluded her remarks and left the bench, the courtroom erupted in quiet conversations and rustling papers. I sat motionless for several moments, trying to process the magnitude of what had just occurred. David was beaming as he gathered our documents. Deborah, that wasn't just a victory, that was a complete vindication. Judge Hayes essentially endorsed your entire approach while rejecting your father's case on every level. But I wasn't thinking about legal victories. I was watching my father, who remained seated at the plaintiff's table with his shoulders slumped in what looked like exhaustion or defeat. Patricia Blackstone was already packing her briefcase with the efficient movements of someone eager to exit an unsuccessful venture. She spoke briefly with my father, but he seemed barely to be listening to her explanations and post-mortem analysis. After the courtroom cleared of most observers, I approached my father's table. Patricia Blackstone nodded curtly and left us alone, recognizing that whatever needed to happen next was beyond the scope of legal representation. "Dad," I said quietly, sitting in the chair his attorney had vacated, "I know this isn't the outcome you wanted." He looked up at me with eyes that reflected a complex mixture of emotions, disappointment, confusion, and perhaps something that might have been pride. "I listened to everything the judge said," he replied slowly, "about the business plans and the financial projections and the foundation grants. I heard all of it, and I still don't completely understand how giving money away makes you successful." I nodded, recognizing that this conversation would require patience and genuine effort to bridge our different worldviews. "Dad, what if success isn't just about accumulating wealth? What if it's about using whatever resources you have to create something meaningful that outlasts you?" He was quiet for a long moment, considering my words. "Your grandfather built his construction business from nothing. He understood that success meant providing for his family and creating security for the next generation. That's what I've tried to do too." "And you did," I assured him. "You created opportunities and security that allowed me to make choices based on what I thought was right, rather than what I needed to survive. But maybe the next step is using that security to help other families have the same opportunities." My father rubbed his forehead, a gesture I remembered from childhood when he was working through complex problems. "The judge said your program helps families avoid deportation," he said finally. "How many families?" "In the pilot program, we helped 180 families successfully resolve their immigration status. If we scale nationally like the projections suggest, we could help 100,000 families annually." He absorbed this information, and I could see him trying to reconcile it with his previous assumptions about my work. That's a lot of families," he admitted. "I suppose I never thought about the scope of what you were trying to accomplish." Over the following hour, we had the most honest conversation we had shared in years. I explained how the Martinez Immigration Legal Center would operate, how it would be financially sustainable, and how it honored grandfather's values while creating lasting institutional change. My father asked detailed questions about business operations, regulatory compliance, and financial projections, approaching my work with the same analytical rigor he brought to corporate law. For the first time, he seemed to see my choices as strategic decisions rather than impulsive idealism. "I still don't completely understand your world," he said, as we prepared to leave the courthouse together, "but I'm beginning to see that maybe I didn't need to understand it to respect it." 3 months later, the Martinez Immigration Legal Center officially launched with offices in New York, Los Angeles, and Chicago. The Ford Foundation grant had come through as promised, providing the resources needed for rapid expansion. Major law schools had signed partnership agreements to provide training and ongoing support. My 30th birthday arrived without fanfare, marked primarily by the legal transfer of full trust fund control as originally intended. But the real celebration came 2 weeks later at the center's grand opening in our flagship New York location. My entire family attended, including my father, who delivered brief remarks about the importance of using privilege to create opportunities for others. His words were carefully chosen and somewhat formal, but they represented a genuine effort to publicly support work he was still learning to understand. Judge Hayes also attended, accepting my invitation to speak about the role of innovation in legal services. After her remarks, she approached me privately. Miss Martinez, I want you to know that in 30 years on the bench, I have rarely seen a case that so clearly demonstrated the difference between technical legal arguments and fundamental questions of justice. You proved that competence isn't about conforming to others' expectations. It's about achieving meaningful results through thoughtful action. As I looked around the opening celebration, at immigrant families receiving legal services, at young attorneys eager to learn new approaches to advocacy, at my family finally beginning to understand my choices, I realized that my grandfather's vision had been achieved. The trust fund battle had never really been about money. It had been about proving that wealth could be a tool for justice, that success could be measured in lives changed rather than dollars accumulated, and that sometimes the most responsible thing you can do with an inheritance is use it to create opportunities for others. 6 months later, when a reporter asked me about the lawsuit and its aftermath, I thought about how to summarize what we had all learned. Sometimes the biggest inheritance isn't the money someone leaves you, I said. It's the example they set for how to use whatever resources you have to make the world a little better than you found it. My grandfather had given me more than a trust fund. He had given me the courage to define success on my own terms and the resources to prove that helping others wasn't incompatible with building something lasting and valuable. That inheritance was worth far more than $12 million. Looking for more? We've got 2 amazing stories ready for you right on screen. If this one touched you, these are absolutely worth your time. Click to watch them now. And hey, subscribe and hit that bell to never miss our latest uploads.